Mr. Steele, please raise your right hand. I solemnly swear that in this proceeding, the material and responses that you submit will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you. You may put your hand down. Mr. Steele, before we proceed, I'm going to discuss with you some very important rights and protections that are afforded you by the Constitution and laws of the state of Texas. Number one, you have the right to remain silent. That means you do not have to make a statement. You don't have to answer questions. You don't have to submit paperwork, especially papers that are that contain a confession or admission of wrongdoing. That's the right to remain silent. You know you have that right.
Yes, sir.
You also have the right to a jury trial. That's 6 people that you and your attorney and the state's attorneys would select from a jury pool of random people from the community. Those 6 people would listen to the evidence and the information, testimony that's submitted, and decide whether you're guilty or not guilty. That's called the right to a jury trial. Do you understand you have that?
Yes, sir.
You have the right to confront or face any witnesses that would testify in your case. That means you and your attorney could question, cross-examine, or challenge any witness who would testify if you chose to go to trial. Do you understand that?
Yes, sir.
There's also a right called the right to appeal. That right you could exercise by yourself or your attorney by himself or the 2 of you together. You'd have to follow the right forms and time limits, but it would be the right to demand that a higher court review the official record, evidence in this case. It's basically called the right of appeal. Do you understand you have that right?
Yes, sir.
You also have the right to have this hearing held in open court. That right the state has also. Their individual rights, your right and their right. We're doing this by video conference because of the COVID pandemic. Nonetheless, it's being streamed on YouTube, so it is public, but not within the requirements of Constitution and laws. You understand you can demand that this be heard in open public courtroom.
Yes, sir.
Right. These rights that I've just mentioned to you, if you persist in a plea, you give up those rights. Do you understand that?
Yes, sir.
All right. Now, the documents I'm going to share with you, have you reviewed these with your attorney, Mr. Aguilera?
Yes.
Do you have any questions about these documents at this time?
No, sir.
All right. Now, these documents, I have them, Patty. Do I have them, Ms. Morgan?
Yes, Your Honor. I emailed them to you.
Okay, then I better find them, huh? Oh. But this, it's not Coy, C-O-Y, right?
What was that, Your Honor?
The name that there is under?
Nicholas Steele.
Yeah, that's what it should be. Did you just send them just now?
I sent them at 1:51.
Okay, well, let me see here. The last one I'm showing is 12:01, so gotta find it.
And then, Judge, as you find it, my client would like to suggest a correct spelling of his last name.
That is, that was reported to me earlier, and I agree. Should be, and we'll make it a record.
Thank you.
I don't have it yet on my computer. Or at least it's not showing it to me. Let's put it that way.
Do you want her to send them to me, Judge?
Give me a couple of moments.
Patty, I copied you as well on it.
Huh. The latest one I've got is 1201 for whatever the reason. Let me see. You look for it and I'll look for it, Patty.
Yes, sir. I found it, Judge.
Here we go. It woke up.
Judge, I have it ready if you want me to share it.
Okay, well, go ahead. Go ahead. Let me get out of this screen and go back to. Alrighty.
You ready, Judge?
Yes, ma'am. Mr. Steele, it's my understanding that there's a misspelling of your name.
Yes, sir.
And first, before anything else, you've been sworn, or I should swear you. Do you solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth? Once again.
Yes, sir.
All right, Mr. Steele, what is the correct spelling of your name?
My last name is Stihl.
Just like the tools company, is that correct?
Yes, sir.
But you wish you had their stock.
Yeah, I do.
All right, Mr. Steele, for the record, I'm going to show you some documents. Those documents at the top will always have identifying information. The case number, which we've already made of record, 619518. It'll say the state of Texas versus Mr. Steele, specifically Nicholas Alexander Steele. And then it'll say that it's in the County Court of Law number 5, Bexar County, Texas. After that identifying information, which will be repeated in all the documents pretty well except one, it'll have the title of the document involved in this case that we're looking at. That title will be in all capitals, bold print. The first one I'm going to show you is in reference to the right to have this matter held in open public courtroom. This one is for the state, because I told you that they have that right also. The state is, what are we getting background noise on? From whom? All right.
Do you want me to close your door, Judge?
I don't think it's from here. But all right, looking at this document, it is the state's consent to the video conference and giving up the right to demand a public open courtroom. Do you understand that?
Yes.
All right. Do you have any questions about this document?
No, sir.
The next document is on what's called discovery. This particular document refers to Article 39.14 of the Code of Criminal Procedure. It requires, it's the state of Texas requires that information and evidence be submitted to you. Everything that's receipts, documents, videos, I don't care what, body cams, whatever is available has to be made available to you or acknowledged to you so that you and your attorney can make a informed and intelligent decision concerning this matter. You understand that?
Yes.
All right, this is signed by your attorney and the state's attorney. They're saying that that has been complied with, okay? Then the next document, that document is your own document wherein you're giving up the right to demand that this be done in the open public courtroom. Did you sign this document?
Yeah, I submitted.
Yeah,
whatever.
okay, just also you the next document is I'm having trouble seeing mine, Patty. What is the title of this one?
Defendant's waiver of constitutional rights
Right.
and court's admonitions.
All right, Mr. Steele, did you review this document with your attorney?
Yes, sir.
All right, you'll notice it starts off with 3 sentences specifically. Hold on just a second, folks.
Now, well, I think we already did, so, that's what, so, but you already gave it to us for today, right? Okay, okay, no problem, all right, okay, bye.
This particular document starts off with 3 sentences. The second one, can you read me what the second one says?
I understand that in this case, I am charged with the following offenses, 0.15 or higher.
Patricia, that background noise is from your computer. All right, now, the second sentence, because they're all, the 3 of them are separated. That one says that you're gonna enter, you hereby enter a plea of nolo contendere to what?
Obstruction, highway, intoxication.
Okay. Exactly, because you started off with what's called a Class A misdemeanor. Punishment of $0 to $4,000 and in jail from 0 days to 1 year. But Mr. Aguilera apparently has gotten succeeded in reducing this 2 levels. Not only does it reduce to DWI first, which is Class B, but also to deferred adjudication. I'm sorry, to obstruction of a highway. You're not getting deferred, you're getting probation, but it is obstruction of a passageway, highway, or waterway. It's taking it down 2 levels. You understand that you're entering a plea of nolo contendere to that charge.
Yes, sir.
Momentarily, we'll be hearing from the state making an appropriate motion for that, which I will grant because I will honor the agreement that you're making with the state. Now, I'm flying blind here, Patricia. Is this the one? That's this one, the one that has 15 divisions, right?
Yes, sir. I'm on my way. I'm on my way.
Okay, Mr. Steele. The rest of this document that we're looking at is divided into 15 different parts or divisions. Each one is numbered. Number 1 talks about the range of punishment. Now, since this is a Class B misdemeanor, the Class B misdemeanor is not only punishable by a lot less.
Hold on, hold on. What did you do?
Like I said, I'm flying blind here.
I don't understand.
I had gotten out.
Oh,
Anyway, those 15 separate paragraphs or divisions Did you read them carefully with your attorney?
They can't.
Yes, we went over them.
Did you understand them?
I believe so.
Okay. And do you have any questions about them right now?
No, sir.
All right, I started to tell you, number one talks about the range of punishment. Since you'll notice there's a check mark there that this is a class B misdemeanor now, it got lowered. That means you can be punished by a fine from $0 to $2,000 and jail from 0 days to 180 days. Is that clear?
Yes.
I want you to read for me number two.
Number two, I understand I have the right to a jury trial, a right to cross-examination of witnesses, and a right to remain silent. I freely and voluntarily give up those rights.
All right. Now, so you can read clearly, you understand what the documents say. One thing I just want to remind you of is that you made a deal with the state. By law, I don't have to accept it. By law, I have to say yes or no to the deal you make. If I decide not to accept your deal, or if I give you a sentence that is within the proper range but is greater than what you agreed to, in either case, the law would allow you to start all over again. Is that clear?
Yes.
All right. You've never been involved with the sex offender registration program?
No, sir.
Okay. And for the record, where were you born?
San Antonio, Texas.
All right. I will note in the paperwork that you are a U.S. citizen. This document you and your attorney both have signed. Is that correct?
Yes.
Okey-doke. This will be signed by the court. It'll be part of all of these documents will be part of the record. The next document you're seeing now has the information that we've been talking about, the identifying information. This is my certification to you. It's called Trial Court Certification, the Defendant's Right of Appeal. There's a series of little boxes that are stacked vertically. The fifth one I am marking for the record, I am declaring to you, this is a plea bargain case and the defendant has no right of appeal. Do you understand what that just said?
Yes, sir.
Okay, you've signed it already and so has your attorney. Is that correct? No, this one does not have your signature. I will have to have that on there. Is that understood?
Yeah. I thought
All
I
right.
did all this.
Now, what we're seeing now is an application for judge-ordered community supervision probation. What that amounts to is probation is up to me as a judge. I will tell you that you made a deal for it. I will honor that, but you need to understand something very briefly. Probation is a written, legal, binding agreement. Once you enter your plea, I will find you guilty. I will include in the sentence or the punishment jail time, but that jail time will be suspended, probated, so long as you live up to 100% of the conditions of supervision. If you fail or refuse to live up to the conditions, then the state can ask me to bring you in after notice, give you a hearing, and go ahead and put you in jail. Is that clear, sir?
I understand.
Okay. Now, for the record also, the conditions of supervision will be read to you. You will sign them. They'll put a copy in your hands. So there'll be no question that you understand what the conditions are. Is that clear?
Yes, I understand.
Okay. Now, the next document is called this is your personal data sheet. I will require you to fill out all the information on there.
Yeah, I filled that out.
Okay. We're being shown a copy that was not filled out. Very good. Who is your employer, sir?
It's the Irish pub on Data Point.
Okay. And I'm not looking for your hourly wage. What is your income?
I make about $3,600 a month.
Are you single or divorced or married?
Single.
Do you have any children that you have to support by law?
No, sir.
Okay. And did you fill out the information on your vehicle,
I did.
sir?
Yeah, I did. Gray Nissan Versa.
Okay, tell me about that a little bit. What vehicle do you have?
It's a gray Nissan Versa. It's a four-door sedan, smaller vehicle.
What year?
2016.
All right. How do you like that car?
Gets the job done.
All right. It is not a pricey Mercedes, but you've got a good vehicle, huh?
Yeah.
All right. So I'm showing you now what's called the plea agreement. The identifying information is minus the reference to the county court law number 5, otherwise it's the same. The first two boxes will be marked for the record. The first one talking about the right to remain silent. It's a very important right, and repeated 2 or 3 times in the paperwork. The second box identifies you as a U.S. citizen. That is the fact. You've testified to it. Then we have in bold print, defendant's acknowledgements. Do you see and understand the things that you have check marked here, saying you understand these rights and protections involved in this case?
Yes.
All right. The next section is DWI specific allegations. Now, the state with Mr. Aguilera has decided to do something about the charge. Ms. Morgan, tell me about that, please.
Yes, Your Honor, the state moves to amend the information to add count 2, an obstruction, and the state moves to waive and abandon count 1 and moves to proceed on count 2 of obstruction.
Defense, any objections?
No objection, Your Honor, from
All
the
right.
defense.
And do you also, does defense waive the 10-day notice on amendment?
Yes, Judge, we do.
All right.
There's no objection.
And also on that basis, motion made and the defense has no objection. I will mark there that the motion is granted. All right. Now, officially, Mr. Steele, to the charge of obstruction of a passageway, highway or waterway, how do you plead, sir?
No contest.
Very good. To remind you, a no contest plea in this court is taken as a guilty plea. Is that understood?
I understand.
And a nolo contendere is in fact sufficient for me to find you guilty. Understood?
I understand.
All right. I hereby order you to appear within 7 days in the offices of County Court Law number 5 to have your thumbprint affixed to the documents required under Code of Criminal Procedure number 38.33. Is that clear?
I understand.
Now, I find you guilty of the offense. That box will be checked. I sentence you to 1 year in Bexar County Jail. That is probated or suspended for a term of 1 year. You will not apply for early termination of community supervision. You are fined $400. This document says that 200 of that is probated. I may address that momentarily. You will perform 48 hours of community service restitution. Scroll, please. All right. As part of the probation or supervision, you will in good faith enroll in and complete the DWI education program. You will submit to what's called a TAP evaluation and follow the recommendations. You will have 6 months of ignition interlock monitor placed on your vehicle. And during those 6 months, you're not to drive any other vehicle other than yours equipped with that ignition interlock. Is that understood?
Yes, sir.
All right. I assess your supervisory fee at $34 a month. Now, let me remind you of something. I have told you that if I give you a punishment that is in any way heavier than what you agreed to, then you'd have the right to start all over again. Now, your attorney had gotten you a deal for $400 fine and $200 probated. Mr. Aguilera or Ms. Morgan, can you tell me why I should accept that as opposed to not allowing probation of any of the fines, since the gentleman makes $3,600 a month and has no dependents.
Your Honor, I believe, and I could be wrong, that Mr. Aguilera was an appointed attorney. And when I see that they're an appointed attorney and I don't know how much the defendant makes, I just assume it's better to have them complete their sentence and be able to complete it if they don't have enough money. And that's why I had probated half of it.
All right, and as I mentioned earlier,
Your
I'm not
Honor.
required to accept that. Yes,
It shows in the system that Mr. Aguilera is retained, hired, not appointed.
Mr. Aguilera, my docket says you're hired. Is that correct?
Yes, Your Honor.
All right. Now, I will remind you again and ask a simple question. Because I'm not going to probate any of the fine, in fact, I'm tempted to increase it. You have the right to say, no, I don't accept that. I'm going to start all over again, or you can accept it and we're through. Mr. Aguilera, or Mr. Steele, do you want to discuss this further with your attorney, or do you want to go ahead and proceed?
Judge, it's my opinion, professional opinion, that we need to go ahead and if you want to unprobate that 200, we're not objecting to that.
I think it's
not one of the,
go ahead.
it's not one of the topics that was conferred about, but when I saw it, I was not going to turn it down, of course. I don't want to say I took advantage of somebody's mistake, but it wasn't something that we did to negotiate. And
All right.
if you want to unprobate the 200,
It's not unprobating it. I'm just not going to grant it because that's, again, we all know that I have the right to. I'm very, very tempted to make it a minimum of $500, but I won't go that far. I will say the fine is $400. None of it is probated. And on your speaking on behalf of Mr. Steele, I will presume or not presume, I am making it a record that you're saying, no, you're going to accept it. You're not going to demand that we start all over again. All right. Mr. Steele, do you have anything to say about that?
No, I don't believe so.
Okay. Then that'll be the record. And I will